Good evening, everyone. Welcome, and thank you for joining us for this evening's webinar on 2020 Vision, a further look into COVID-19 employment issues. I would like to take a moment to introduce tonight's presenter, Ken Gray of Ward & Smith. Ken's practice experience encompasses various areas of employment-related litigation. He advises clients and litigates cases involving all forms of employment discrimination, wrongful discharge, and breach of employment contracts from small startup companies to Fortune 500 corporations. Ken is a frequent lecturer on employment discrimination, workplace retaliation, workers' compensation, and wage and hour law issues. Again, thank you for joining us. Before Ken begins, please note that he is going to utilize a few PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both his video and the slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose the side-by-side mode. The slide deck should appear on the left and Ken's video should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues, please reach out via the Q&A feature and we'll try to troubleshoot with you. Now, I'll turn the mic over to Ken so we can begin.
Good evening. We did this presentation for your group a couple weeks ago and got a lot of good feedback, and we had a number of questions that night, and we decided that this time, instead of presenting a PowerPoint presentation from the beginning, we're just going to go ahead and dive into the questions that have been submitted and dig a little bit deeper into them and make explanations. And I think once we work through all these questions, it will answer a lot of questions that folks may have out there. Certainly feel free to take advantage of the question A, the Q&A feature on this webinar, and we will, if we have time, try to get to those questions as well. So with that, we'll get to our first question.
Okay. If we have an employee we changed from salary to hourly due to reduced office hours from COVID, are we able to change them back to salaried once we can increase our office hours?
Okay, the very simple answer to that is yes. And what we're talking about here is somebody that's an exempt employee, which means that you do not have to pay them overtime if they work more than 40 hours in a work week. Now, you can't just say that somebody's exempt. They actually have to be exempt based upon the duties that they perform. And certainly your optometrists are going to be exempt. Anybody that's an RN level will be exempt. Your HR person will be exempt, potentially your comptroller, your office manager. Those are people that are typically exempt as long as they do not have too much non-exempt responsibilities. But what we're looking at here, and this is something that a number of practices across the healthcare industry has implemented, and it's basically taking folks who had a salary, they didn't have a contract, and so they're just an at-will employee, and they were salaried exempt employees, and at a certain point, the practice changed them to exempt hourly employees, which meant that they did not have to work, well, they didn't have to get paid even if they weren't working. So when they were an hourly employee, as this question deals with, then you just have to pay them for the actual hours they work at whatever the hourly rate that's designated by the practice will be. If the person was salaried, on the other hand, if they work at all, then they're entitled to be paid their full salary for that particular day. And so that's a good reason why some practices have taken people from salary to hourly. And so to get back to the question, yes, that person can be converted back to salary at any time. You just need to give them 24 hours advance notice for anything that is not in their favor from a compensation standpoint For example, if you reduce somebody's compensation, it has to be given, they have to be given at least 24 hours. If you want to increase it, you could do that retroactively because that's to their benefit. But so the answer to that question is yes, you can change that person back to salary.
Okay. And Ken, while you were answering that question, we did have a question come in through the Q&A portal. It is, if I have a patient who is high risk, say 75 years old and diabetic, who needs an eye exam, i.e. he has good reasons to be seen, do we need to have them sign a waiver saying they understand the risk?
For patients, that's not a bad idea. And that's the first time I believe I've received that question in regards to a patient or a customer of a business. But what the question I've been getting is, can we have our employees sign a waiver? And the answer to that is, while you can do it, it's typically not really worth the paper that it's written on in terms of your employees. If your employees contracted illness at work that's specifically due to their work, then they could have a claim against the practice for workers' compensation, and you can never contract away somebody's rights for workers' compensation before the claim has even arisen. So in that situation, you couldn't. Now this gets a little bit beyond this question, but it really does relate to another issue, which is we're going to see some lawsuits come out of this from employees and from customers, patients in situations where they contract COVID-19 and they claim that they got it at a certain practice or business, and they may have gotten it at the gas station, but they're claiming they got it at a practice. And in that situation, it would be good if the person is a patient, they certainly can sign a waiver. It needs to be very narrowly tailored, and that's something that we could help with. Make sure that it's a very narrow, not just a generic one that you pull off the internet. It needs to be very specific, and in fact, it needs to talk about COVID-19. But yes, that's not a bad practice, and I would recommend that practices have their patients sign such a waiver. Okay.
Thank you. So moving on to the next submitted question. As we gradually reopen, we want to bring back staff part-time, but still want them to get the unemployment benefits, particularly the $600 bonus from the federal government. Do you know how many hours an employee can work before they lose unemployment benefits, and particularly the $600 a week federal money?
Okay. It's more a function of how much they make as opposed to how many hours they work. Now, just in general, pre-COVID-19, and it's still the law in North Carolina, if your hours are cut by 50% or your compensation is reduced by 15%, then you can apply for unemployment if you leave the employment. They have relaxed the rules for COVID-19, and you do not have to actually leave the employment. But the rule is this: the maximum for North Carolina purposes, not the federal, but the North Carolina purposes, is $350 a week. We all know that. We know that's the way it's been for years. And what the law says for this partial unemployment under North Carolina law is that you can earn up to 20% and not affect the unemployment benefit. So let's take, for example, the maximum of $350 a week. 20% of $350 is $70, 1/5. So you can earn up to $70 and you can still get the maximum of $350 in unemployment from North Carolina. For every dollar that you go over 70, though, it reduces that $350. So if you earn 75, then the maximum of unemployment you can get is $345. And so, yes, every dollar you earn over 70 does reduce that person's amount of unemployment. All the way up to $420 a week. At 420, you're now $70 over 350, and it would make sense that that's what wipes out unemployment together. So then the next question, the bottom part of that question talks about the $600 a week in federal money. Under North Carolina law, nationally, you must earn at least $1 of state unemployment to be eligible to get the $600 as a regular employee from the feds. But in North Carolina, that number is 15. So in North Carolina, you cannot work enough that you would really earn more than, say, $405 in a week, because that would leave you only $15 of state unemployment, and you got to have at least $15 of state unemployment in North Carolina for you to be eligible to get the $600 of federal money. Okay, so to answer that question, how many hours was the person can't make more than $405 in a week and be eligible for the federal $600.
Okay, and then got two questions that came in. One relates back to the question that you just answered, and is, I have an employee who is getting the $600 per week who does not want to work all of our hours because she does not want to lose her unemployment. When does the $600 run out?
Well, and let me just say this, and I mentioned this before. It is not good practice to tell your employees how much they're going to get, how long they're going to get it. Frankly, we're still trying to discern what the government's going to do with this thing. And I'll just reiterate what I said last time, which is, if you remember a decade ago when we had the financial crisis with the banks, folks ended up being on unemployment for over 2 years at times. And so we don't know what the government's going to do, how many different waves of governmental assistance is coming. And I'm very hesitant to state how long somebody's going to get it. But I would say, I would just go with the general parameter that I answered that question before. As long as they make less than $405 in a week, they should be able to get the $600 of federal unemployment. Now, and that's assuming that they already are at the maximum amount. Certainly, if they typically only earn $200 a week, then that's all they would get, and then they obviously can't get as much more than that without it causing them to lose the NC unemployment, which means they'd lose the federal as well. So this will go, there's different components of the unemployment. There's another question we have later on that talks about self-employed folks or sole proprietors. And that will talk in terms of how long those folks can get unemployment. That's a specific number, and I'm comfortable getting that number. But with regular employees, we're still not sure how long they're going to be able to get it. And it just kind of depends on what North Carolina has been slow to establish all of its rules. So we're still trying to wade through that.
Okay. And then the second participant question that came in is, do employers need to verify with NCDES that someone has been laid off due to COVID-19? I have been receiving notice of unemployment claims in the mail after the respond by date. While I do not have any claims to refute, I want to make sure that my unemployment account isn't charged and my rates do not increase.
Well, as long as the employee is stating that the reason he or she is needing unemployment. In other words, the reason they got laid off was due to COVID-19. And if the DES does not get a response within 10 days from the employer, then it should automatically grant the employee's unemployment claim. And because it references COVID-19, it should not be chargeable to your account. I would want to keep checking with DES to make sure that that is in fact the case, that for some reason it didn't get miscoded as not a COVID-19 case and thus a regular case where the employer did not respond, and so it very well could get charged. And frankly, there are mistakes that DES is making. We did have a client who had an employee that got laid off due to COVID-19. That's what the employee said when she applied for unemployment. The employer got a timely response from DES and submitted it that same day and said, yes, it was due to COVID-19. And then the person got denied unemployment benefits. And now they're appealing and they will get them, but there are glitches and there are mistakes that are being made. And you got to understand, North Carolina DES has never, ever seen this level of cases before. So it is making mistakes, and I've heard of other mistakes as well. So it would be beneficial to check and make sure that it got coded the right way if you can ever get through to anybody. It's extremely difficult to get through to folks right now. I tell people to call after hours or try to log on after hours, but you got to be persistent.
Okay, thank you. So the next question is, can my employer stop paying me but not put me on furlough?
Okay. Well, that is a loaded question. Essentially, if you stop getting paid, you're on furlough. So in a way, it's a misnomer. The employer has furloughed you. Now, the question is, can the employer stop paying you? And that they may be able to do so, particularly if there's no employment contract and you're not doing work, then yes, they can stop paying you. And essentially, by definition, that is a furlough. You're still an employee, you're just not getting paid. Now, if you have an employment contract that designates a specific compensation rate that you're supposed to be getting, like a salary, then they may very well be stuck with having to pay you even though they're closed, but that's a different issue. But to answer this question, can my employer stop paying me but not put me on furlough? Yes, but they really are furloughing you. This is what happened to the federal government employees years ago when the Congress couldn't come up with a budget and they started furloughing folks. You can call it whatever you want to, but they're not getting paid. They're still employees, and so that's a furlough. Now they can apply for unemployment in this situation.
I'm an independent contractor at a Walmart Vision Center. I eat what I kill, no W-2 or 1099. The Vision Center has been closed since mid-March. Am I eligible for unemployment? Also, is the $600 weekly federal unemployment dependent on getting NC benefits first?
And we had this question last time, and at that time I said, certainly you can apply. We're not certain that you can get anything, but there's no harm in applying. However, as we have been able to dig deeper into the CARES Act, we did find out that Section 2102 of the CARES Act created a new temporary, this is temporary now, this isn't going to go beyond COVID, but it's a temporary federal program entitled Pandemic Unemployment Assistance, PUA. And it provides for up to 39 weeks. So this is the number I was talking about, 39 weeks of unemployment benefits. And PUA covers individuals who are not eligible for state unemployment generally, such as independent contractors and self-employed workers. But these individuals can apply, and you can also be eligible to receive the money under the federal $600 amount. So again, I would not tell somebody that's an independent contractor that you're absolutely going to get it, because frankly, that's just never been the case. But the government does appear to have created an exception to that general rule, and you certainly should apply if you're an independent contractor, if you're self-employed, a sole proprietor, and even if you've not paid unemployment insurance on yourself, you can file. Whether or not you'll get it, that'll be up to the government, to DES. If they deny you, you certainly have a right to appeal, and maybe a hearing officer will turn it around. So I'll answer this one fairly similar to what I said last time, which is there's really no harm in applying. We just, as practitioners, don't typically see independent contractors getting it, but there is a law that says you can. So I would go for it.
Okay, great. And we've had 3 questions come in from participants. Would you like to answer those now? Okay. The first is, what do we need to do if one of our employees' household family members gets COVID? Or if one of our employees gets COVID, what is the office responsibility?
Okay. Now, I think this question is coming from a safety standpoint as opposed to a Families First Coronavirus Response Act standpoint. In other words, do we have to pay them sick leave? Because as we talked about last time, due to all of you being in the optometry business, you're a healthcare provider, and you have a right to exempt your employees, or if you're an employee, your employer can exempt you from coverage from the paid sick leave or the paid FMLA. They'd have to do so affirmatively, and they can do so if you ask them, I'd like to take advantage of those, or I think I'm entitled to those benefits. Then they could say, no, we're going to exempt you because you're an employee of a healthcare provider. So what I think this question is getting to then is, okay, if we hear that one of our employees or is sick with COVID, or they have a family member, should we take action to protect the rest of our workplace? And the answer is yes. It would get back to the same premise that we've heard from day one, which is those folks need to quarantine. And you have a right as the employer to tell your employees, you got to go home and quarantine for X number of days. You can certainly seek health department guidance. That would be probably a wise move. And if you get something in writing from the health department, that would be good, because you can show you're trying to comply with governmental orders. And but I would definitely send that person home. In fact, there's going to be there are certain states have rules that if you travel from one state to another state, you must self-quarantine for a certain period of time. So yes, it will make sense to require folks to go home and not come in for a period of time. At least 7 days, and you can't go wrong with 14. If they have PTO to use, you certainly can allow them to use PTO. If the person does not have PTO and they've worked part of that week and they're a salaried exempt employee, they're going to be entitled to be paid for their regular salary for that entire week, even if they only work the first day of the work week. But any week in which they do not work at all, then you do not have to pay them for a full week that they're out if they do not have PTO to take.
Okay. Next is, are the unemployment payments retroactive if they have not yet applied? Paren, an employee didn't apply.
You could put, what I would do is I would put in the date that you became either unemployed or your compensation got cut by more than 15%. So if you took a hit financially, you can go back and assert it to that date. And if the government determines you're entitled to unemployment, then it typically does go back to the date that you put down that you became entitled to benefits.
Okay. My protocol for seeing patients is for all employees and patients to wear masks. Do either employees or patients have a right to refuse to wear a mask?
A patient certainly does not have a right to refuse to wear the mask. If they do refuse, you can suggest that they leave. You have a right to demand they leave. And so the patient does not have that right. And I'm trying to think of any scenario in which an employee would have a right to refuse. The only thing that would come to my mind would be if for some reason it was against somebody's religion. But, and I'll give you an example, like there are rules about people having to shave to wear respirators in areas in which OSHA requires respirators to be used. But there are religions that prohibit men from shaving their beards. And, a company wanted to know, could it terminate somebody who would not shave due to his religion? And the answer to that is no, you cannot terminate that individual. Instead, you're obligated to go buy them a full face respirator that is appropriate for people with beards. So, but COVID-19 is a game changer, and we've never seen anything quite like it before. The EEOC has indicated that it has relaxed its standards as long as the employer is acting in a legitimate manner. And frankly, the more I'm talking, the more I just cannot see that the EEOC would ever say that an employer violated an employee's rights by demanding that they wear a mask due to this pandemic. Because we're asking everybody to wear it. We're not singling people out. And you certainly could single out folks that had symptoms if you wanted to. But frankly, I think the answer to that is no. But if you have an employee that raises the religion issue, you need to seek legal counsel before you take adverse action against that employee, just to make certain under your particular circumstances that you and your counsel are comfortable with that and taking adverse action.
And there was a follow-up comment to that question. Can people refuse a mask if it causes difficulty breathing?
Well, I mean, it gets back to essentially the same answer as before, which is with a patient, if it causes difficulty breathing and we don't want to see that patient because we're concerned, then you can ask that patient to come back when they are able to wear a mask, or we come up with some other alternative to see that patient. So frankly, and it may be that you end up having to discharge that patient from your practice, but hopefully we get to the point where we're able to see folks just like before. But I think we're always going to have a heightened level of the need for PPE going forward for the immediate future. And I'm talking about the rest of 2020 probably. So that is going to be a difficult issue. We've got to, perhaps there will be ways that folks can accommodate those patients. Maybe we could give them a face mask and make sure that the people that are dealing with them not only have a mask, but have a face shield as well. There are options where you may be able to see that person, but certainly you have a right to demand that they wear a mask, and if they can't, then you know, you have a right to refuse to provide them treatment at that time. An employee in that scenario, if they, it's a little bit different issue because they potentially could claim they have a disability that, such as asthma, for example. Severe asthma could be classified as a disability, and they may not be able to wear a mask. So what are the other options? And what we would have to do is explore, can we accommodate this person? Is there some other mechanism that we could, you know, allow them some type of accommodation and they can still do the essential functions of their job? And part of that is keeping people safe. And sometimes you just simply cannot accommodate a person. So it's going to be a fact. Unfortunately, there's no bright line that we can draw here. It's every disability accommodation issue is a case-by-case basis. And so it really is a balancing act of whether we can accommodate the person or not. But the one thing is clear, you must try to assess whether you can accommodate the employee. Otherwise, the EEOC will automatically say you've done disability discrimination because they want to see that you've gone through that interactive process of trying to discern whether you can accommodate.
Okay. So moving on to one of the questions that were submitted prior to the webinar. Can a sole proprietor collect unemployment if they are not on a fixed salary and never paid unemployment on themselves?
According to the CARES Act, as I mentioned earlier, they should apply, and they very well may be able to collect unemployment for the first time ever based on the CARES Act. So yes, they should apply. I'm not going to be in the business of telling somebody they're going to get unemployment because I don't want to speak for the government, but it looks like they can apply and get unemployment.
What is active without pay?
Well, that sounds like the earlier question of not getting paid but not being furloughed. Essentially, it's furloughed. The person is being furloughed. In that situation, you're still an employee, you have employment rights, and you could apply for unemployment, just like if you were laid off.
Okay. We've had a few more questions come in live. The first is, do we have to report it to anyone or do anything special to the office besides a thorough cleaning?
Well, one thing I will tell you is we're in the process of putting some articles out and coming up with our own policies about this, but it's going to be important that we take extra measures. I think every practice on here needs to have a policy. Everybody needs to make sure they get plenty of PPE, and because you're such a facing patient business, you're going to have folks wearing masks, and everything needs to be cleaned each time. And that's what, I mean, that's always been my experience anyway, is they would always wipe down the machines and before they put them up to my eyes. And you're just going to have to make sure you're doing that, and you're going to need to be periodically wiping down the door handles, and everything that a patient touches is going to need to be wiped down. And so that was the question about, do we need to tell people?
It just said, yeah, does it need to be reported to anyone?
Not really, other than you need to have a policy and you need to provide training to the employees. So in that capacity, you are reporting it to the employees because you're telling them we have a policy, we expect you to abide by it, and here's what we're going to do, and you may have to provide some extra training. And so we're going to have to be a cleaner environment than we were before.
And then it was asked if you could repeat the part about a contracted employee cannot be put on unpaid status even if their location is closed.
Okay. And we see this with the physicians and maybe some mid-levels, but if you are guaranteed a salary in an employment contract, so for example, I'm guaranteed to be paid $50,000, or let's say $52,000 a year, so that's $1,000 a week, and we're going to be closed this week due to COVID. They still have to pay me my $1,000 that week. So unless for some reason I'm the one that's not available to work, then any week I do not work the entire week, you do not have to pay me. But otherwise, if I'm available to work and the only reason I'm not working is because of the employer shutting its business or being required to shut its business, then I'm entitled still to be paid unless I have what is called a force majeure clause in my employment contract that says if there is a natural disaster or pandemic, then this contract is null and void, or we do not have to pay you for that during that period of time, then you're entitled to be paid. Now, I can tell you, I do not see a lot of force majeure clauses in employment agreements up to this point. We've actually drafted some for companies and they're going to use them going forward. And so we're going to see those a lot more, but we're not seeing any of them in contracts up to this point. And so there's a good chance, it's all dependent upon the language of the contract. And so you may need to get a lawyer to take a look at your contract, but I have advised many practices that they've got to pay folks unless they can go and get them to agree to modify their contract and take a lesser amount. And many folks have done that because they wanted to keep working and not have the practice go out of business. So I can think of one practice in the western part of the state. I won't give the type of medical practice it is, but they had 16 mid-levels that they basically got to reduce their compensation by half, and 15 out of the 16 agreed to modify their contracts and do it. And then the other one, they just simply gave them the 30-day notice and to terminate the agreement. So yes, if your contract reads the right way, you may be entitled to be paid even if the practice is closed.
Okay. Then there was a follow-up related to that same topic, and I think you may have already touched on this, but can a contracted employee be furloughed?
If we're talking about one of those folks that I just mentioned that has a contract that is written well enough that it protects them and they're entitled to be paid even if the practice is closed, in that situation, they're entitled to be paid even if they do get furloughed. But again, it depends on the language of the contract. And there are many contracts that, even though they say you get $120,000 a year, there's an out. For example, it may say the employer can, increase or reduce this amount in its discretion. Well, in that situation, they can reduce it, and they've not violated the contract, and they can reduce it to zero. So it depends on the wording.
And then switching back for a moment to the pre-submitted questions, the next one is it a breach of contract if I am not being paid?
If you have it in it, that same question essentially, which is if you have a contract and it's written such that it protects you and the employer doesn't pay you, yes, they have breached the agreement. But again, it depends on the wording of the contract.
Okay. Can I accept another position even if my contract stated I needed to give a 90-day notice?
Well, that's a good question. You actually should comply with your contract. As a lawyer, I'm always going to tell people to abide by your contractual obligations. However, Frankly, I don't know what an employer is going to do if you don't give the requisite notice, unless they have built in penalties for not giving that. For example, many companies say we'll pay you your accrued but unused vacation at the time you terminate, but if you resign and you don't give the proper number of days notice, then you forfeit that accrued but unused vacation. Some people do a bonus if you give the requisite notice, but if there's no teeth, if there are no teeth that are built into the contract, then the employer would have to sue you and prove its damages, and that may be difficult, particularly in this situation. But I will tell you that I would never on a webinar advise somebody to not give the 90-day notice without first contacting your legal counsel to see what the consequences are based on your particular contract.
And this next question I think may have been answered from one of the previous participant questions. Will unemployment insurance back pay if I wait a week to apply?
Yes, it'll get back to when you first became eligible for the unemployment.
Okay. So this is going to start with a fact pattern and then lead into a few follow-up questions. In late March, my company liquidated all PTO. They cut checks in the amount of accrued PTO to furloughed employees taxed as supplemental earnings.
Okay, let me just stop you there, and they can do that. Okay.
Those employees still active were not given PTO checks, but told that their PTO would be set to 0 and no more opportunity to accrue or use PTO for the remainder of the year. My contract includes PTO.
Okay, let's forget this last sentence about my contract includes PTO, because I think it calls into question some other issues. There are a lot of issues in this question, and basically we start with saying that if you can go back to that previous slide,
sure.
The active employees were told that their PTO would be set back to 0. Well, that may not be possible for that employer. It just depends on what its PTO policy is. But if people have already accrued PTO, which it seems like, given that some were paid out PTO, then the employer very well may not be able to do this. But again, it's going to depend on what their policy is. In North Carolina, companies are not obligated to give PTO, but the Wage and Hour Act says if you do, then it's governed by the employer's written policy. And if the policy doesn't have specific forfeiture provisions, then you don't forfeit vacation or PTO, and it looks like there's a forfeiture here. And so I don't know without seeing the actual documentation, but this sounds suspicious to me that the employer may be overreaching here. Now, going the next step and saying that people can't use it for the rest of the year, there's a good possibility. An employer can always change a PTO policy going forward. It's just that you can't retroactively do it to the detriment of employees. So a company can change it going forward and say no more PTO from this point forward. Now, if it's in your contract that you're entitled to X amount of PTO, then you're entitled to X amount of PTO, and it doesn't matter what they change their policy to. You're entitled to be paid for that amount. So that would be a breach of your employment contract.
So the next fact pattern is I am a salaried employee. In late March, my company furloughed most staff but kept the doctors on paid status. The company paid the doctors at their weekly base pay rate, yet required the doctors to work beyond normal hours and days listed on their contracts. Although the hours and days were more, the duty was lighter. And the question is, can the company ask me to work beyond my normal contracted hours and days for the same pay rate?
Yes. They can, as long as there's nothing in a contract that limits how much the person is making. A company can always ask somebody to work more, and if they're an exempt employee, then they can. I mean, I'm an exempt employee, and I get paid the same compensation if I work 35 hours, 40 hours, or 60 hours a week.
So in this fact pattern, I am a salaried employee and have a contract with my company that lists yearly salary, PTO, etc. In late March, the company furloughed most staff but kept the doctors on paid status. I remained on paid status for 6 weeks. On the 7th week, I was suddenly told by the company that I would be put on active unpaid status and given information to file for unemployment with no date on reopening my clinic. There was no clear explanation for my duties while under active unpaid status. During this unpaid time, I have been contacted by my regional boss twice, and I've been contacted by patients that have my phone number. The company has also texted me and asked me to go to my clinic to do a favor for them while I'm on active unpaid status.
Okay.
Can the company still contact an employee that they have put on active unpaid status?
Well, first of all, there's a lot of issues in this question, and I see some things that the company is not doing appropriately. And can they put somebody on unpaid status? Well, it depends on what the contract says, because this person at the beginning said they had a contract. Some contracts are very vague and don't get to the real details of things, and you could be put on unpaid status and you would be able to file for unemployment. Can they ask you to do work during that time? Yes. Just like we talked about earlier, you can make some money and still not affect or do away with your unemployment. Now, this gets on to, I think there's a part in here. Let's see, what's the next question? What does this active unpaid status mean as far as the contract is concerned? It depends on what the contract says. This very well could be a breach of the contract. May need to have this reviewed by legal counsel. The next part of that is, has the company broken their contract with me? Depends on what the contract says. Very possibly may be the case. I won't make my yearly salary listed in the contract now that I've been put on active unpaid status. Well, that may be a breach. It just depends on what the wording and how much of a guarantee it is that you were to make that actual salary. And then they finally talk about that all the communications have been pre-recorded audio messages that got sent to our email. There is nothing in writing. The Wage and Hour Act says that changes that are talked about in here should be in writing. Now the question is, given the fact that it's generated or you're receiving it through an email, does that mean that it's writing? Could be. That may suffice, but there's an argument that they haven't complied. But I would argue they probably have if they got an email and it's an attachment to an email.
I am a salaried doctor. My contract lists specific days that I work and the location I work at and the hours per week I work. The company is trying to reopen, but says that scheduled days and times will change. I do not want to work these new days and times. I had the original days and times wrote in the contract for a reason. Can the company require me to return to work beyond the days and hours listed on my contract?
It depends on what the contract says, and that's going to be an answer you hear me say a lot. But just because a contract says you work Monday, Tuesdays, Thursdays from so-and-so to so-and-so, it doesn't mean that you can't also be asked to work on, Fridays. And or maybe the contract says that you can't be asked. And so it really gets down to the wording of the contract. this is a potential breach of the contract, but we have to take a look at the actual language to determine if there's any wiggle room for the employer.
I'm an associate doctor for a private practice, paid by the hour, 40-hour work week. For 3 weeks, my boss paid me as if I was working 40 hours. However, he told me to stay home until he found out more on how to operate the business during this difficult time. He then asked me to come back to work for 40 hours, again with a full patient schedule, but said that I owe him back 120 hours for those 3 weeks he paid me to stay home. My boss also shared with me that he applied for and received the PPP loan. Can my boss ask for me to repay those hours, especially concerning that he was paying me with PPP loan money? By repay, the boss is proposing I work overtime off the books.
Okay. This particular doctor is saying he's paid on an hourly basis. If that's the case, they have made him a non-exempt employee, and he should not work off the books or work for free overtime. And also, the boss cannot ask him retroactively to pay back this 120 hours that he's gotten paid. So this boss is being heavy-handed and is probably skirting on the wrong side of the law, and that boss needs to check with his counsel, and I suspect his counsel will advise him that he can't do everything that he's suggesting of the employee doctor.
If a full-time employee has a medical reason for not coming back to work once we open up full-time, what are our responsibilities and liabilities? Our company is not under the FMLA or Family First Act, but we have indicated that we would follow the main guidelines for maintaining employment.
Well, and if somebody is just afraid to come back because they feel like they may be susceptible to getting COVID, that is a them problem and not an employer's problem. And you can certainly allow them to be out and allow them to use PTO, but at the point that there's no paid time off to take, you can either put them on unpaid status or you can replace them. At some point, you've got to have people that are going to do the job, and you've got safety measures in place, and you've got to get on with serving your patients. And so if we don't have, if you're not willing to come in and do the job, and you're not sick, that would, you don't have an illness that would prevent you from coming in, then we've got to move on. So there will be now that's, depending on what kind of condition the person has, they may have some pre-existing premorbidities that would necessitate you to potentially accommodate them under the ADA. And this is going to be an issue that you probably need to consult with your legal counsel on.
And once they transition from unemployment to this extended leave of at least 12 weeks, how do they handle employee benefits such as health insurance?
Now, I'm not quite sure I understand this question. When people, it says when they go from unemployment to extended leave of at least 12 weeks, I don't quite think I understood this question when it came in. I think it was an anonymous question. So I'm going to just say that we're moving from unemployment and the person has, we're opening up and they're not willing to come back to work. So we're going to put them out on up to 12 weeks of, say, unpaid leave. Maybe that's what this particular practice has. Okay, in that situation, how do we handle insurance benefits? Well, it would be the same situation as if you were putting, it depends on what your policy says. If your policy says that the employee would be responsible for it, then the employee is responsible. If the policy says that the employer is responsible, then the practice has to pay for it. It just depends on what it is said in the policy. If the policy is silent, and then that's when you need to, let your counsel take a look at and determine if you should continue to pay for it. There's a good chance there are definitely going to be circumstances in which an employer would have to pay for it, particularly if we had a true FMLA situation. I think they mentioned earlier they're not an FMLA company though. So in that situation, there's a good chance that they could require the employee to have to pay for that. And also historical precedence is going to take place. Have you had any similar circumstances like with people that came back from maternity leave or say automobile accidents or cancer? How did you treat those people? And you're going to have to treat this person very comparably. It says, are they eligible for these benefits, and do we need to notify our insurance company that they are not working full time? You should, and your insurance company may say that they've been out of work for a length of time that they're not entitled to coverage any longer. And in that situation, you would end up giving them a cover notice. Can they accumulate paid time off while on extended leave? That depends on what your policy says. If your policy does not say that they will not accumulate paid time off while on extended leave and they're still an employee, then they probably should be entitled to accumulate PTO. And then it says our handbook indicates PTO is an accumulation per pay period, not a lump sum given at the beginning of the year. But it doesn't say that you actually have to be paid during a pay period. And so I would need to take a look at that particular policy. That it may be enough to indicate that the employer doesn't have to pay it, but it needs to be pretty clear on that front.
Okay. And that was our last submitted question.
Okay.
We do have a number that came in during the call. Would you like me to just start going through those?
Let's go through and see how many we can get.
Okay, perfect. So the first question is, does it make sense for an owner to file or apply for emergency paid sick leave for themselves if they did not work to care for a child if they could not work to care for a child whose school was closed? Or is this just a benefit to help employees?
An employer could actually file for paid sick leave under the Coronavirus Family First Response Act, but it would have to pay 2 weeks of their, if they've had a triggering event, and this gets back to our first presentation, which you've got to have either a governmental order shutting you down, or the health department telling you to quarantine, or you've been diagnosed with COVID, or a healthcare provider has told you to quarantine, or you're having symptoms of COVID and you're seeking treatment. In those situations, you can get up to your average daily rate up to $511 a day for up to 2 weeks. But if you don't have, and then there's 2 other scenarios, one in which you're taking care of somebody that has COVID or is under a quarantine order or been told to stay at home by a doctor, or you have a child who's out of school or daycare or childcare due to COVID. In those 2 situations, you can only get 2/3 of your average daily rate, capped at $200 a day. But if you don't have one of those 5 triggering events, then you're not entitled to take advantage of that paid sick leave under the federal law. But if you do, then you can pay yourself, and you're entitled to a tax credit for those payments.
Okay. The next one is, do we need a form to be signed by patients and or employees that we are complying with all recommended PPE and precautions for our office, and therefore are not responsible if they were to contract COVID while in our offices?
No, it will not be worth the paper it's written on in regard to employees. Patients, it really won't be worth anything to them either. Now, that's a little bit different than what I said earlier. If somebody is, I think that was an example of somebody that was 75 years old and coughing, and so it was somebody that was suspect. I mean, you can have your patients sign a waiver stating, we recognize we're going into a medical environment, and there's potential risk of coming in contact with viruses, including COVID-19. However, I understand that this practice has implemented various safety protocols and sanitizing efforts, and I waive any claim that I may have against them. Now, that may not be enforced by a court, but it won't hurt to have that. You don't have to have that. I won't go out and say that companies or practices need to do that, but if somebody asks me, can we do that and will it be effective? Yes, you can do it, and it may be effective. It may keep people from suing you that otherwise get it. So I would not tell anybody it's a bad idea in regard to patients. Let's see, we're at 9:01. I think we have 7 more questions. Let's run through them, and I'll go through them just as quickly as I can.
Okay. What is your advice if an employer has said that we are now unpaid, but we are entitled to our contracted pay? How should we fight to get those pay benefits?
You could raise the issue with your employer and give them a chance to do what's right. And then if they do not agree with you, then I suggest you seek legal counsel.
My contract outlines my PTO. However, my employer has stated they have drained PTO banks in order to pay staff. Is this legal?
Most likely not, but it will depend on what the employer's policies say. They potentially have changed their policies right before or as we were heading into this pandemic. I don't know if they notified you of that or not. I know some companies did do that legally. But then if you've got accrued benefits, they can't make you zero those out. So it just depends on what the policy says, but they may have done a no-no.
Does an employee have the right to refuse to come to work because they are afraid of contracting COVID? Does an employer have the right to release them for refusing to work?
Certainly, we don't have indentured servitude, so an employee does not have to come to work, but they may not have a job at some point. So ultimately, I would be understanding, but you've got to have employees to get the job done. And so if they're not cooperating and it really isn't a good reason, and we really do need to have somebody do it, and there's no way to get around it, yes, we're going to have to release them and get somebody else to do the job. I do suggest you deal with your legal counsel in that regard.
With a breach of contract, does that mean the entire contract is broken, i.e. cannot be enforced unless re-signed by both parties?
Okay, excellent question there, because what that may be getting at is a lot of folks have contracts that have non-competes in them. And there is a case in North Carolina that says if a practice violates like the compensation provisions, does that negate the non-compete? And the court said no, the non-compete is still in effect. So if it does not necessarily negate all of the obligations in that contract. So that will be a legal question.
Okay, and this next one is 2 parts. My employer sent an email last week stating that they are no longer paying our base salary and have converted us to the same hourly wage across the board. Is this legal or breach of contract if I have a contracted annual salary?
Well, it may be illegal or it may be legal. It depends. For example, if you just had a contract that said, like a lot of people do, you're entitled to, let's say, $100,000 is your starting salary, and it will be adjusted as we go forward in the employer's discretion, and the contract doesn't have any definitive time period, then the employer can potentially change that. So it depends on what the wording of the contract says. So there are contracts in which an employer can do exactly what you talked about, and there are contracts that they cannot. So it's all contract dependent.
Okay. And as a follow-up to that same question, they have also now stated that this hourly wage will be paid as a daily wage, and salaried employees are not eligible for overtime.
If I'm understanding the question correctly, they're saying that they took the salaried folks, they're paying them on an hourly basis on a daily rate, a daily basis.
An hourly wage will be paid as a daily wage, and salaried employees are not eligible for overtime.
So I guess they're saying we're converting people from salary to hourly, but if you were salary before, you're not going to be eligible for overtime. That could potentially be a violation of the Wage and Hour Act. There is an exception for doctors that may apply. It does apply to doctors. So it depends on who this person is that's asking the question. But I have a suspicion that the employer may be doing a no-no here. If it just depends on who is involved and what they're doing. Now, frankly, if they're not working overtime, or the practice that says we're not going to pay overtime even if you work it, well, that's a no harm, no foul. But if they're working overtime and they're getting paid on an hourly basis, we may have a problem there.
Okay. And this is the seventh question. If you received a PPP, can you hire different employees to keep your employee number the same as before you received the PPP?
Absolutely. Okay. Yes. In fact, you should. We're basically telling folks not to fire people during this time, or if you do, you need to replace them so that it does not mess up your PPP loan because you want as much of that forgiven as possible. So, of course, now certainly you got some folks that are just so bad you got to get rid of them, and we might forfeit a little forfeiture. But in essence, yes, they look at FTE, comparable FTE. So if you replace somebody, you've kept that number at 1, so you're good to go.
Okay, great.
Okay.
Thank you, Ken. Thank you for everyone that joined us tonight. For those of you in attendance following the webinar, you'll be sent an email with several of our labor and employment articles that are related to some of the issues that Ken discussed this evening, and also a link to sign up for our COVID-19 newsletter. In addition, we will have a recording of this webinar available. In the current uncertain business climate caused by the COVID-19 pandemic, we understand that many North Carolina Optometric Society members have questions related to employment issues or other matters. As we've seen tonight with the questions that were pre-submitted and submitted during the webinar, many of these issues are nuanced or particular to individual society members or their practices, and we'd like to offer the opportunity for a 1-hour consultation with one of our experienced labor and employment attorneys. The flat fee for this session is $400. For more information, please email Terry Eubanks at toe@wardensmith.com. We so appreciate you taking the time to join us and hope that you are able to take some of the information you learned this evening and apply it to your own business. Thank you again. This concludes our webinar.